Many people have asked me the question whether it is okay to have some kind of utility knife with you that's got a folding blade and maybe a corkscrew in the event that you might want to use the corkscrew or something else on the utility knife at some point whilst carrying it around. So that is the question I'm addressing today, but please bear in mind that this is just one specific example that I'm going to talk about, and you cannot just blanket apply this to every different scenario, although it will give you some kind of guidance, and of course you must always seek formal legal advice. But that aside, welcome back. I'm the Black Belt Barrister, helping you to understand law and giving you one example of whether or not you are allowed to carry around a utility knife that has a knife attached that does not comply with the law. So let's go back to basics for a brief recap on the law on carrying around a blade or other pointed article. Section 139 of the Criminal Justice Act 1988 makes it an offence to be in possession of a blade or pointed article in a public place unless it is a folding pocket knife, which I'll come back to in a moment, or you have lawful authority or a good reason, such as using it for work, religious reasons, or part of some kind of national costume. And in order for it to come within the folding pocket knife exemption, the blade must not lock and it must have a cutting edge of not more than 3 inches. And for the avoidance of doubt, this edge does not have to be sharp. For example, a butter knife is not ordinarily sharp, but this has been held to be a bladed article for the purposes of the Act. Nor does it intend that the cutting part of that blade is 3 inches. If the overall length of the blade is 10 inches and only a sharp bit of it is 3 inches, it is a 10-inch blade for the purposes of the Act. So with all that in mind, I'm going to tell you about a case called Crown against Giles of 2003. Giles' case ended up at the Court of Appeal Criminal Division for exactly this offence, for being in possession of a bladed article in a public place. You see, Giles had been arrested for being in possession of a multi-purpose utility tool that contained a lock knife with 8 centimeters of blade. Now remember, a locking blade does not come within the folding pocket knife exemption. So what happens in these cases is that there is a burden placed on the defendant to raise a good reason or lawful authority for having such a bladed article with them in a public place, so as to act as some kind of defense. However, in this case, Giles had argued that this multi-purpose utility tool he had with him was because it could be used for any number of legitimate everyday uses. Therefore, Giles argued that he did not need to give a specific lawful reason for having this with him in a public place, because he might use it on any occasion and simply carried it around with him at all times by way of habit. The judge at the original trial, however, had directed the jury to convict him on the basis that he hadn't raised any such defence, and he was therefore duly convicted. Therefore, the case found its way to the Court of Appeal on the argument that the original judge was wrong to withdraw this matter from the jury and direct them to find him guilty. The Court of Appeal, however, agreed with the original judge and dismissed the appeal on 2 bases. First of all, that Giles' habit of having this tool in his possession without any particular intention to use it for a lawful purpose at that specific time didn't amount to a good reason, and second, that the judge was correct to withdraw this matter from the jury. The Court of Appeal looked to and followed an earlier decision in the case of DPP and Gregson of 1993 and concluded that the onus was on the defendant not only to raise a defence of having a good reason for carrying this article in a public place in the first place, but also a specific reason for having it in his possession at that very moment in time. And the very fact that this blade was part of a multi-purpose tool that he had the habit of carrying with him at all times was not a specific reason, as followed in the case of Gregson. Accordingly, Giles' appeal was dismissed and the conviction upheld. So in this very specific example, where Giles was carrying around a multi-tool which had a blade as part of it, which was not legal under the Act, it wasn't sufficient for him to say that he might use this multi-tool purpose for any specific purpose at that moment in time. Contrast this perhaps with a situation where, let's say, you are going camping and you've got many different purposes for the multi-tool. This is much more likely to substantiate a specific and good reason for having that with you at that moment in time, even though it contains a blade which does not come within the exemption of a folding pocket knife. There are, of course, lots more cases, lots of other examples, so if you want to see those, please subscribe, like the video, tell me in the comments that you like these explanations of these specific examples of being in possession of a bladed article in a public place, and I will come back and do more of those. So in the meantime, thank you for watching.